Good morning, students. So today we will be talking about the Sale of Goods Act. What are the terms that is involved in this chapter? So this act best specifically concentrates on sale of goods and services. Okay, what are the regulations that is available, and what is the benefits that is available for the person who's been aggrieved, right? Who's been not provided with proper goods and services. So here we will be talking about this Sale of Goods and Services Act. Okay, Sale of Goods Act 1930. So till 1930, the transactions related to sale and purchase of goods were regulated by the Indian Contract Act of 1872. So since when we saw in the previous chapter Indian Contract Act, under that only the subsection was talking about Sale of Goods Act. Okay, Sale of Goods. The rules and regulations were formulated and given by Indian Contract Act. Later, there was a need for the provisions or regulations required for these things. So that's when they had passed a bill in the parliament, and that's when they had converted this particular act into a separate new act that is called as Sale of Goods Act of 1930. So it was actually came into existence in 1930. That's why it is called as Sale of Goods Act 1930. Okay, so Indian Contract Act. So 1st September 1872 with section 266 sections. Okay, so here we see the subsection 76 to 123 is talking about sale of goods. So which I was telling you guys about this in the previous slide, right? So here 124 to 147 it talks about indemnity and guarantee, and then 148 to 181 it talks about the bailment and pledge, and 182 to 238 talks about the agencies, and 239 to 266 talks about the partnership. Okay, so partnership also comes here in Sale of Goods Act. Now here in 1930, section 76 to 123, sale of goods was removed from the Indian Contract Act of 1872, and a separate act called the Indian Sale of Goods Act of 1930 was passed. It came into existence on 1st of July 1930. Okay, so with the effect from 22nd September 1963, the word Indian was also removed. Okay, now the present act is called as the Sale of Goods Act 1930. That is a little bit of brief history about how the Sale of Goods Act came into picture. Okay, then we have definition of contract of sale. So what do you mean by sale of contract? So section 4 defines the contract of sale as a contract whereby a seller transfers or agrees to transfer the property in goods to the buyer for a price. Now here the seller is actually agreeing to transfer the property of goods. So when the property of goods is transferred, in turn the buyer have to pay a compensation to the particular product which he buys. That's when the ownership gets transferred. Okay, so essentials of a contract of sale. So in the previous chapter we spoke about the essentials of a valid contract. So there were few essentials which spoke about the essentials of a valid contract. Now here we will be talking about essentials of a contract of sale. Okay, so first one is two parties, and the next one is goods, and the next one is transfer of property, and then is price, and then essential elements of valid contract. So what is two party? You know that for a person to get into contract of sale of goods and services, there must be at least two parties involved. There should be a buyer as well as the seller. There cannot be only seller to sell the goods, right? There has to be two people involved in it. A buyer means a person who buys or agrees to buy goods. So section 29 subsection 10 talks about this. And then seller means a person who sells or agrees to sell goods. Section 29 subsection 13 talks about this. Okay. Goods. So what do we mean by goods? Goods that is movable property, not the immovable ones. So land, building and all are not the goods that is termed in this act. Okay. And the sale of immovable property is not covered under Sale of Goods Act. The consumable goods, the movable goods, right? The commodities, those are the termed as goods here. So transfer of property. So here the property means the ownership, right? So in a contract of sale, it is the ownership that is transferred in the case of sale, or agreed to be transferred in the case of agreement to sell. So you're agreed to sell. That's a contract, right? You will pay later, as against transfer of more possession. So here there is an agreement to transfer, right? Price. So you buy anything in the market, you purchase anything, you don't get anything for free of cost. If it's for free of cost, it would probably be a gift, or which is not for sale, right? The consideration in a contract of sale has necessarily to be in money. Okay. So when there is no consideration, it amounts to gift and not sale. Okay. So that is what it means. For instance, goods are offered as consideration for goods. It will not amount to sale. It will be called as a barter system. So in the ancient times, there was barter system, right? I give you cow, in turn you give me 3 bags of grains, right? That was the thing which was followed before. Okay, so that is not termed as goods, wherein there is no consideration here. The money doesn't come here. It will not be termed. Okay, there should be a consideration for the goods. Okay. To sum up, the act applies only when the buyer pays by cash or by check or credit card, etc. Okay. Essential elements of a valid contract. All other essentials of a valid contract as per the Indian Contract Act of 1872 must be present. Okay. So here two parties to the contract must be competent to the contract. The consent of the parties must be free. The object of the contract must be lawful, and so on. Okay. So sale and agreement to sell. Okay, what do you mean by sale? Where under a contract of sale, the property ownership in the goods is transferred from the seller to the buyer. It is called a sale. Sale is executed contract. Okay, what is an agreement to sell? An agreement to sell means a contract of sale under which the transfer of property in goods is to take place at a future date or subject to some conditions thereafter to be fulfilled. Okay. So we'll see the differences of sale and agreement to sell. So in contract, it is an executed contract. In agreement to sell, it is an executory contract. Okay, transfer of property. The property in goods sold passes to the buyer at the time of contract. It passes immediately. Agreement to sell is after fulfilling certain conditions, then only the transfer of ownership happens. Okay, conveyance of property. It creates right in rem, right against things. It gives right to the buyer to enjoy the goods against the whole world. It creates a right to personam, right to engage, okay, right to enforce a particular person, his obligation. Okay, transfer of risk. The transfer of risk takes place immediately if there is loss of goods. It will fall on the buyer. There is no transfer of risk of loss of goods as ownership is not transferred. The loss will be faced by the seller. Okay, so rights of a seller in case of breach. So what happens in terms of sale? Since the property has passed the buyer, the seller can sue the buyer for price of the goods. Okay, so the seller can only sue for damages unless the price was payable at a particular date. Right of a buyer in case of breach. He can sue the seller for damages. He can sue the seller for damages. Okay. Insolvency of seller in possession of goods. He can claim the goods from the official assignee. Okay. That is the officer of the court. Okay, whom the person is nominated. He cannot claim the goods, but only your rateable dividend for the money paid can be received by in agreement to sell. Insolvency of insolvency of buyer before paying the price. So the seller has to deliver the goods to the official assignee. The seller can refuse the goods to the official assignee here in this case. Okay, so classification of goods. So the goods are actually classified into three different types. The goods may be classified as existing, future, and contingent. Okay, these are the three criteria wherein the goods are being classified. So what is then existing goods? So existing is nothing but the goods which is possessed by the seller at the time of contract, owned or possessed by the seller at the time of contract. Okay, so existing goods can either be classified into two types, that is specific or ascertained, generic or unascertained. Specific goods means goods identified and agreed upon at the time of contract of sale is made. Okay, ascertained goods is to normally used as synonym for a specific goods. Okay, generic or unascertained goods are indicated by description, not specifically identified. For example, here, Anthony, who owns a TV showroom, has 20 TV sets and agrees to sell any one of them to Bharati. The contract is for unascertained goods, since which particular TV shall become the subject matter sale is not individualized at the time of contract of sale, right? So here a person is not claiming, making a statement that what TV is gonna sell, right? He's just telling he's got 20 TV. We don't know what brand of TVs are available, right? He agrees to sell any one of them to Bharati. Okay. Classification of goods. And here future goods. It means goods to be manufactured or produced or acquired by the seller after making the contract of sale. Okay, so here Kulkarni agrees to sell future crop of a particular agricultural field in the next season. This is an agreement to sell future goods. Okay, contingent goods. These are the goods that the acquisition of which by the seller depends upon a contingency which may or may not happen. Okay, contingent goods is a part of future goods. Example, here agrees to sell Vivek a certain painting only if Chetan, its present owner, sells it to her. So this painting is classified as contingent goods. So there is some contingency in goods to be sold, right? After some condition is fulfilled, only then the goods is transferred to the buyer. Okay. So the next topic which we will be moving on is conditions and warranties. So conditions and warranties are available in section 11 to 17. So what is a condition and what is a warranty? Section 12 subsection 2 defines a condition as a stipulation essential to the main purpose of the contract, the breach of which may give rise to a right to treat the contract as repudiated. So in case you breach any of the conditions that is given, so there is certain elements of contract, right? Elements of sale which you, if you don't fulfill those conditions, your contract is not treated as uh, a valid contract. It will be cancelled. Okay, so what is a warranty? So it is here in which after the agreement has happened, you give a certain warranty to the product, right? So in case if there is any breach of the contract or something, so it will give rise to the claim. Like if you have a warranty, now all of us have uh, have these gadgets and mobile phones and things. If something happens, you have an insurance or warranty card with it attached to it. If something happens, you can go get it done at a free of cost, right? If any repairing of electronic gadgets like a laptop, fridge, washing machine, and anything, same thing applies here. That is what a warranty means. Okay, so it defines as a stipulation collateral to the main purpose of the contract, the breach of which gives rise to claim for damages, but not to the right to reject the goods and treat the contract as repudiated. So, effect of breach of condition is to give the aggrieved party to right to treat the contract repudiated, that is cancelled. If price has been paid, the buyer can claim the refund of price plus damages for the breach. Okay. In case of breach of warranty, only damages can be claimed. For that, the buyer must accept the goods and claim for damages for the breach of warranty. Okay, so what is an express conditions and implied conditions and warranties? So express conditions and warranties are those which are expressly declared or specified in the contract. Example: time, place of delivery, and price of the product. Implied and warranties are those which are implied by the law, which is very important to be followed. Okay, so implied conditions, one is the condition as to title. The seller is supposed to have a good title. He should not have, for example, I'm a person who's selling a car. I've sold it to someone. Later, a person gets to know that that is a stolen car. So it doesn't have a title. It has a title as stolen car, right? Which is not a valid. So that is the condition where he has to have a proper title. Okay, sale by description. Sale by description and specification. The goods should conform to the description and specification. So what you have told, like now the water bottle you purchase, it is a copper water bottle. But wherein what you when you buy the product, the description what is given, copper water bottle, is not matching with the water bottle which is there. It is a normal insulated water bottle, right? Which is not right. So when you're making a sale, the description and specification should match with the description which you actually give to the buyer. Okay, sale by sample. Bulk of goods must match with the sample, and the buyer has reasonable opportunity to comparing the bulk with the sample. Now, if you want to buy a bulk, you want to like actually test that sample, right? Only when that is good you will buy the product. They will give free sample. Now there is a person who which happened a real incident that has happened. He tasted the wine. He's a wine bar owner. He wants to like buy wine and beer, okay, alcohol. And what happened here is when he tested, the wine was very good, but when he actually got to know that in the wine bottle they have added the hair dye, which led to the controversy. So it should be matching the sample. Sale by description as well as by sample. If the sale is by sample as well as by description, the goods must correspond with the sample as well as the description. The condition as to quality. The quality of the product should match. Okay. So this comes to the end of this topics. Okay. Thank you.